So welcome once more, Fortune. So maybe to start us off, in terms of the disciplinary process, for it to be actually initiated, there has to be some offenses that maybe an employee may have committed during his course of employment. So essentially, this goes down to the idea of gross misconduct. So what really is gross misconduct?
Okay, so a gross misconduct is any unethical or unprofessional behavior committed by an employee at the workplace, which is in violation with their terms and conditions of employment.
Interesting. So for this gross misconduct to run itself, it means that there are some offenses that may have been committed uh, to be considered as a gross misconduct. So, what are some of these offenses themselves?
So the Employment Act has listed some offenses. However, I do recommend your HR policy manual to have a comprehensive list. So some of the offenses, according to the Employment Act, include but not limited to absence of work without permission. There is insubordination, unwillingness or improperly performing your prescribed duties. There is fraud or dishonesty, coming to work while you are intoxicated,
Okay.
Use of abusive language, just to mention a few.
Uh-huh. So, with regard to the offense itself, so somebody has committed a gross misconduct. I believe this has to go with the severity of the offense itself, right? So, with regard to this particular employee having committed this offense, what will be the first maybe step that could be their line manager, could be their supervisor? What will be the first step they'll take?
So once the case comes to the line manager, he or she may issue a caution to the employee or have some sort of informal discussion. So if I give an example, if the employee has been coming late to work, then the line manager can speak to this employee to improve their behavior, at least to be reporting early to work, before this case is escalated to the HR department. So they have a discussion, that's the employee and the line manager, and have some sort of internal agreement before the case is escalated.
So I believe also this internal, conversation or discussion between themselves has to be in confidence.
Yes, it is in confidence and not documented.
Yes, definitely. So once an employee has been, brought to attention that ABCD is not going well with regards to their performance at work, or if they've actually done something, I believe it then warrants, if maybe this particular offense is quite severe, and also some offenses might not be that severe. So with regard to either way, whether it's severe or not, what should be done really?
Okay. So once the informal discussion between the line manager and the employee has taken place, but the employee still repeats this misconduct or there is no improvement in the behavior, then the line manager can report the matter to the HR department. The other side is if the severity of the misconduct is too big and the informal discussion between the line manager and the employee cannot happen, then the line manager can take the case to the HR department. So what happens once the HR receives the matter? They send a show cause letter to this employee, and the employee is given at least 48 to 72 hours to respond to the show cause letter. Once the employee responds to the show cause letter, the HR receives this response. Now it's up to the HR to decide if the response is satisfactory or not satisfactory. If it's satisfactory, then the process ends at that point and the case will not proceed because the employee has answered the allegations which were listed on the letter. But if the answers are unsatisfactory, then the HR will now commence with the disciplinary process.
So, with regards to the HR now commencing this disciplinary process, do they really need to suspend the employee if, say, the gross misconduct itself is quite severe, or what happens in between? Because definitely, from being suspended, I believe it warrants some form of investigation. Yeah.
Yes. So suspension will depending on the case. Yeah, the cases where you won't really need to suspend an employee. But there are also other cases, for example, if there are fraud allegations, you will need to suspend this employee.
Yeah.
Yes.
So once they've been suspended, they've actually already done their show cause letter. They've been suspended to allow for investigations. This particular investigations, definitely the HR department will be involved. I believe the line manager or the supervisor will also be involved. What other parameters need to be set out in between?
Okay. So if I may clarify first, the suspension comes after the response of the show cause letter has been done. And now, depending with your HR policy, the suspension may be with pay or without pay, or also with half pay.
Okay.
The Kenyan laws are not very clear if when an employee is suspended, they should be on full pay, half pay, or without pay. So that goes back to your internal HR policies.
Okay.
Yes.
So the investigation was commenced. Probably the employee is within the office premises or outside. So whenever they get suspended, the usual action would be that uh, there's some form of distance between the employee and the workplace, whereby some aspects will be suspended with regard to their access to their email, access to the office. And this is normally done to ensure that there's some idea of, depending on the severity of the offense, some time for cooling off between uh, the employee and their presence at work, to safeguard from the interference of evidence, and also to safeguard on the idea of even just protecting this particular employee and the employer during this particular period. So once the investigation has started, the HR will definitely be part of it. The line manager will also be part, and the investigation will commence. Immediately after investigation, what tends to occur? Does the employee now just goes directly to the hearing process, or is there something in between?
Okay. So once the investigation has been done, there will be some findings.
Okay.
Let's assume probably there was a committee, internal committee, which was tasked to investigate this matter, or even a third party was involved to conduct this investigation. So once the findings have been brought to the HR office, a disciplinary committee is constituted. And this committee shouldn't be biased. It needs to have representatives from different departments. So, for example, if the employee affected sits in the finance department, I'm assuming there are probably 3 or 4 other departments in the organization. So the line manager of the finance department, that's probably the head of the department, needs to be present in that hearing. There needs to be a HOD from the other 3 or 4 departments, at least just to give also an independent opinion. Then the HR will chair the disciplinary hearing. So once the committee has been formed, what's the next step? The hearing date is set and it's communicated to this employee. Remember, this employee was suspended. Let's say with half pay, full pay, or no pay. Once the date is communicated to them, then the letter needs to set out clearly that these are the allegations which the employee needs to come and answer to in the hearing. They are also allowed to come with a witness, but this witness must be a fellow employee or a colleague within the company, not someone who is outside the company. Once the employee receives this information, If they are part of a trade union, then this trade union also need to be informed of this hearing.
Yes.
Yeah, probably a shop steward within the company will also be part of this hearing. Actually, must be part of this hearing.
Yeah.
If there is a trade union, but if there's no trade union, then the employee is at liberty to come with an employee and a witness who is a fellow employee.
Yeah.
Yes.
So, well, actually, with regard to the law, we do notice that most of the times when these particular hearings are being set up, or an employee has been summoned to attend a disciplinary hearing, there's always the aspect and the big question of representation. Because ideally, not all organizations have their employees joining a trade union. So what normally happens is most case law has captured that once the employee has been summoned to a disciplinary hearing, by virtue of the employer bringing in a third party to maybe sit in this particular hearing, the employee, him or herself, is also at liberty